Hey, Attorney LaKanya Murray, the small business attorney, helping clients throughout the United States with trademarks, copyright, and business development solutions. If this is your first time with me, thank you, welcome, come again. I like to come here on Thursdays and answer your questions that you have, because I understand what it's like to be a business owner in different stages and just have questions and not really know where to turn to, or even if you're on the right track. So a lot of times people sit in silence and they just operate in ignorance because they haven't asked. But you guys, not you guys, because you guys have asked. All right. So today's subject, because we got a lot of great questions in, a lot of great questions. Today's subject is going to be mainly around trademarks and copyrights. So I'm going to go over some of the questions. Let's see. The first question is that someone wants to know if it's true that if you at least do a search on the USPTO's website, that would offer you some type of protection if someone comes behind you and submits a trademark for the same thing. The second one wants to know, how long does the process take, the trademark process and the copyright process, and how do you copyright your work? And then if we have time, I'm going to address these questions because I think they're really good. When it comes to developing a business, should you get a business license first and start small, or do you just go ahead and invest in your license? And when you're starting a business, when is the right time to put it out on social media that you're starting a business? So, all right, like I said, really great questions, really great questions. So let's get started. I'm going to address this first question. Will a USPTO trademark search protect you if someone else comes behind you and submits a trademark application for the same thing? Well, let's talk about this. Your trademark application search, the reason that you do it is to make sure that you're not conflicting on anyone else's mark. I often have to advise my client that if you do this search, let's say you do the search on a Tuesday, but you decide not to file until 4 months later. Just because you searched 4 months ago and the mark was available, if you didn't register, chances are someone might beat you to the punch. And in that case, if you're not already using your mark, you could lose out on that trademark, because in the United States it's first to use. And so by you waiting such a long time between you submitting your trademark, doing your trademark clearance search, and submitting your application, you're opening up yourself to, first of all, you open up yourself to increased attorney fees, because even if you are entitled to that mark, it's going to be more work for that attorney in order to defend and argue about why you should have priority. Okay? Second of all, if you're not using the mark correctly, let's say that this is something that you were thinking about using, but you're getting everything together, and you're launching your project or your business in 6 months, and you wait that time, and in 6 months you're like, okay, I got everything together, I'm ready to register my mark, but in the interim someone else registered it. Guess what? You just wasted so much time, so much money, so much effort, because you don't have a trademark, because someone beat you to it, because you weren't using it. And trademarks, if you don't use it, you lose it. So don't wait. That's my big thing. Don't wait. But however, if you have done the trademark search and you find that your mark is available and no one's using it, and you submit your application, and then someone comes behind you and submits their application for the same mark in the same class, with the same related services are good, then you have standing. Then you have priority over that second user. Okay, so it's not just about the trademark clearance search. It's about you actually doing something with the mark. And I have a lot of people that's, they want to do the search, and then they want to kind of get the money up and come back months later, and I tell them that defeats the purpose. I would actually recommend that you do another clearance search just to make sure that nothing's happened. Okay, so that is question number one. Excellent question. So we're going to jump to the next question, which is, how long does this trademark process take? That's a really good question. The trademark process itself can take anywhere from 9 to 18 months, or even longer, depending on the status of your application and if there's something that you need to do. Meaning, so this is what happens. when a client retains me, first thing I do is a trademark clearance search, and I can typically get that done within 24 hours. Then we do the application and make sure you have the right specimen. And when we submit your application, it goes and it sits with USPTO for 3 months before it's assigned to an examining attorney. 3 months, it just sits there. But the great news is your protection starts from the time your application was submitted. Okay, so you don't have to wait until that application has actually been processed before your protection starts. You get that protection, it's going to be backdated from the time you submitted your application. Awesome. So during the process, people, it takes 3 months to get to an examining attorney. The examining attorney looks at it. Often, they send out an office action. Sometimes you might not get one. Oftentimes you do. I've been finding an increased number of office actions for things that, never mind, that I feel are obvious and don't need to be addressed. But that's why my clients retain me, because even if it's something that has a legitimate argument, the argument still has to be made. Okay? And if you don't know how to make the argument, a lot of people, especially when they do it themselves, they just give up, they just quit, they just lose their money. When in actuality, if they just would have went a step further, they would have had their trademark, which is why my clients retain me. So that whole process from submitting the trademark clearance and submitting your application can take anywhere from 9 to 18 months. However, if you submit an intent to use application, and remember that's the application that you fill out and complete if you are not using the mark yet, but you have a bona fide intent to use it. Okay, if you fill out one of those applications, it can take up to 3 years before your mark is registered, simply because after the approval process, you get 6 months to complete your statement of use. Your statement of use is proof of how you're actually using your mark in commerce after they said you could. But you can ask for an extension. You can ask for an extension every 6 months up to 3 years. So that's why that process can take longer if you're not ready. So that's why that process can take longer. So excellent question. The next question is, how long does the copyright process take? The copyright process is a lot shorter process. Typically anywhere from, I guess, 3 to 9 months you can get a copyright completed, and the same thing is backdated from the time you submit your application. The biggest question that I get all the time from people is, what is the difference? What is the difference between trademarks and copyrights? So here we go. We're going to break it down, keep it plain, make it simple for you, okay? The difference between trademarks and copyrights is as follows. Trademarks protect brand identifiers. Brand identifiers can be your logo. It can be a specific color that's associated directly with your brand. Think Tiffany. I always give this example. Tiffany and Company, the jewelry company, that shade of blue they have, that's specific to them. No other jewelry company can advertise or use that shade of blue as it relates to jewelry. It can be a sound. Who was it, ABC or NBC that had the dun dun dun, the little chimes? That was a long time ago. They don't use that anymore. But those chimes, that sound is a trademark sound. It can be a shape. The iPod Classic, the big one, is actually I believe they have a trademark for that. So it's anything that sets you apart from your competitors from the consumer's point of view. It helps consumers readily identify the source of a good or a service. That's what a trademark is. Okay? That can be a tagline. A copyright, on the other hand, it protects original works that are fixed in a tangible form. Oftentimes the two overlap. So by original works, that can be music. And if you're thinking about songs, in one song you can have multiple levels of copyrights that belong to different people. Because you have the person that arranged the music, you have the person that wrote the lyrics, you have the person that's performing it. All those people have different copyrights in the work that they did. Okay, because it's an original work that they created. It can be a poem, it can be a book, it can be a painting, it can be several different things. Sometimes the trademarks and the copyrights overlap, and I think that's where the confusion comes in at. They overlap because let's say you have an original work. let's say you are starting a business and you want someone to design a logo that just represents your brand to the T. You're not a graphic designer, so you don't know. That's not your skill. You want to hire someone so they can stay in their lane and will operate in their greatness. So you hire someone and say, hey, design this logo for me. They create a logo. It's an original work. So that's a logo. That's a copyright. First thing you need to know is if you hire someone to create that logo for you, they're not an employee and they're not doing it in their scope, in the scope of their work, then that person that created it owns that work. I don't care if it's a logo. I don't care if it's pictures being made. I don't care if videos being recorded. They own that work because they created it. I don't care if you paid them. So anytime you work with people or artists in that manner, you must discuss copyrights. It has to be something that you guys discuss. It should be addressed in the contract. It has to be something that you guys discuss. Because if not, that artist owns that work and you are not free to do with it as you want. They can limit how you use it. Oftentimes I know that someone, graphic designers, will create a logo for you, but you're not allowed to use it for commercial purposes, meaning that you can use it on your business card and on your letterhead, but you cannot put it on a t-shirt and sell those t-shirts. And they can limit you that way because they own the copyrights to it. But as I was talking about is the overlap. So you have that original work, which is a copyright, but then you also have that logo that's a brand identifier. The reason that it's important to know or to protect it on both fronts is because they offer different protection. You know, they have different statute of limitations of when they expire. So you want to make sure that your intellectual property is covered on all fronts. Cool beans. Let's see. The next question is, oh, I did that, we did that. So, moving on. We talked about intellectual property. We talked about the importance of not just searching and making sure that your trademark is not infringing on anyone else's, but acting in that moment. You want to act in that moment. You don't want to wait. And kudos, it's great. I know so many people that do trademark searches or don't do trademark searches, and they just go and jump on and invest in creating this brand, and then they call me, and then we're scrambling trying to figure out how to make it work because there's some sort of conflict. Don't do that. Do the trademark clearance first. Make sure you're not infringing on anyone first. Protect your intellectual property first. Okay? And speaking of first and what you should do first, that brings us to the next point. When it comes to developing a business, should you get a business license first or start small and then get a license? So I think what you should know when it comes to getting licenses and starting businesses and things of that nature is that everything you do may not be a business. Okay? If you are selling goods or providing a service but you're not making a profit from it, if you're not making any money from it, then you don't have a business. And you can talk to my friend Falashade, the entrepreneur accountant, and she would talk to you about what the IRS considers a business. After years of a loss with no profit, you don't have a business, and I think they will shut you down, but she can talk to you about that. So if you don't have a business, like if you don't have a legit business, then you probably should focus on making sure that you have a business. The way that you do that is planning. You guys have to plan. You guys have to write. You guys have to have goals. You guys have to execute, take steps in order to have a successful business. Depending on what area you're in, you absolutely have to have a license before you do anything. Like for me, I'm an attorney. I can't practice law without a license at all. And that's my professional license. But then you also have your business license with the city. And if I'm an attorney, I'm a licensed attorney, but I'm not working or getting any clients, I don't have a business. I don't need to go out and get a business license. But once I do have a business, then you need to get a business license. There is no starting small or wait till you make a certain amount of money before you get legit. You need to start legit. You need to start with the end in mind, because it's so difficult once you start to go backwards and try to get everything straight. You need to handle your business in the very beginning. And when you start a business, when do you start advertising that business on social media? And not just social media, just when do you start advertising businesses in general? And this is, again, this is my answer to that. When you're in business, everything should be strategic. Nothing should be by chance. So I can't say that you should get on social media 3 months before you start your business, or 3 months, because first of all, what you want to do is make sure that you have a business and that you don't just have an idea. Because if you have a business idea and you post that on social media and you haven't made any steps to do it or execute it, it's up for grabs. There's no protection in ideas. You can keep that with a trade secret. And a lot of times the advantages that we have as business owners and new businesses is the element that no one's doing it. If you found a space to operate in and you see that no one's doing it, and instead of acting, you just talk about it, after so long of talking about it, somebody is going to come in and take that idea, and then you're going to sit mad because someone stole your idea. People can't steal ideas, okay? They cannot steal ideas. So if you haven't started executing on that idea, then don't share it on social media, okay? And be selective of who you share it with offline. But when it comes to sharing, when it comes to advertising and letting people know, it needs to be strategic. You need to think about what your end goal is, what business you're creating, what project you're launching, how much time it's going to take to get the people's attention, and create a plan specifically for that. Advertising and even social media, even though social media seems so simple because we use it oftentimes for personal use, you have to realize that all that stuff, is on purpose. Everything's intentional. You need to have a plan, and a plan specifically for social media. How are you going to use it? Do you even need social media in your business? Don't just use social media because that's what everybody's telling you that you need to do. Does your business legit need social media? And these days, most of the time they do. But go a step further. Why does your business need social media? How can it help you? And start developing a plan around that area on how it can help you. So if you want to use social media in order to get people to your email list, in order to get people to communicate with you so you can sell products, you need to create content and a schedule that does that. Okay? These were some amazing, amazing questions, you guys. So if you are just coming in, hey, how you doing? My name is Attorney LaKanya Murray, and I am the small business attorney, and I help clients throughout the United States with trademarks, copyright, and business development solutions. I put the call out for questions. You guys came, you left your questions, and they were awesome questions. If you have questions, make sure you drop them in the comments. Make sure you email me or Facebook message me your questions, and so maybe next week you'll see your questions here on Ask Me Thursdays. All right?